and Karen Truskowski. Will the parties please introduce themselves for the record?
Kevin Winkers, Your Honor, on behalf of the
I know O'Brien, Your Honor, on behalf of defendant.
All right, thank you. This is the time that's set for a continuing case involving property at the Montego address. And this was the time set for an order. I do have a proposed order that was submitted to the court by Mr. Winters. And if I remember correctly, there was a request for the $30,270.96 was the reasonable fees that had been indicated for the record. And then there were some defendants are provided J.K. Winters with a copy of their Michigan driver's license. The defendants are to sign and have a notarized quitclaim deed to the plaintiffs. And then all previous orders issued by the court, the circuit court would remain in place, which would be inclusive of the conditional dismissal that was originally a part of the case. I have it prepared by Brian. You've had the opportunity to review this.
Your Honor, which order? I've been presented a couple of orders.
It's the order dated of today's date, which was yesterday, June 28th. Today is the 29th. Have you seen that order? It's not dated, it's not signed, but it is coming out of the June 22nd date. Have you had the opportunity to look at that order?
She does, Your Honor, because she sent us back a marked up.
Is that the order that I was sent from Lori?
All right.
Okay, I apologize, Your Honor. It's just there's been several orders.
All right.
I want to make sure that we're talking about the same order.
All right.
Would this be number one? This order applies to the defendants jointly and severally?
Yes.
Okay, yes, I have that order.
And you've reviewed it?
I have, and I do not agree with it.
All right. You do not agree with it?
That is correct.
All right. So Mr. Winters, this is your order. Ms. O'Brien, what about the order do you not agree with?
Okay, first of all, and this is something I did not object to. We have been communicating this week on this order. And looking at the caption, this was not brought jointly and severally. So they're as to number one, this order applies to defendants jointly and severally. It's my understanding that needed to be pled from the very beginning.
From the very beginning, it's been Truskowski, David Truskowski and Karen Truskowski. Is that correct?
But it wasn't. That is correct, and it may be just an issue of semantics.
Okay. All right. So on to your second complaint.
The second thing is under the money judgment and regarding the attorney fees, it should end at the $30,270.96 figure. And submit payment directly to J.K. Winters at his address in full by August 31st. And the defendants can make payments prior to August 31st. That portion of it is what we object to. First of all, the court didn't order that these payments be made directly to J.K. Winters. And further, the court did not order any specific time in which they had to be paid. My concern with this provision is that it would subject my clients to contempt proceedings if they don't pay it by August 31st. And we already know that they're not going to be able to pay it by August 31st. So I'm setting them up for contempt charges if I agree to that provision.
All right. And Mr. Winters, it sounds like a collections issue more than anything else.
Well, let me tell you what has transpired. We have been going back and forth on this issue, on the payment issue, and that was proposed $250 a month with no collection. I couldn't collect, the firm couldn't collect anything. Less nonsense. You know what I mean? No enforcement action.
All right, I'm gonna have you just talk a little bit more into the microphone, just so we can pick you up. Yeah.
So, did you hear what I said?
Yes.
Okay.
Yeah. So I'll reiterate it. I'll reiterate it for the court recorder. Initially, there was no indication of a collection issue process that it was a sum certain on a certain date. Is that a fair
Well, the
statement?
first one we wrote, we did have one language added, and if you missed a payment, we returned to the collection.
Correct.
And something like that, so we took that out.
So that was so. What was initially in the conditional dismissal?
Well, I don't know off the top of my head.
Because that's what went up to the Court of Appeals, and that's what was affirmed. So whatever language is in the conditional dismissal is the language is going to be the nature But I do agree that there should be a place, an understanding of where to send the money. And the defendants can make payments prior to August 31st is really a request that is really an indication of where to send the money before August 31st, 2023.
If they
Not,
want to.
not a mandate.
No, if they want to.
Right.
You can't make it much easier.
Correct. So,
Grace, that's not what we had the issue with. It's, you understand, Your Honor, that I can't set my client up for contempt.
correct.
When really you're correct. It's a collections issue. They can take whatever collection proceedings they have available to them. We don't have any say-so over that. But to give them a date certain that they have to pay the funds. Now, I know on a standard eviction, there would be an order, you pay X amount of dollars by this date, or you move out. But that's not the language here. So you pay X amount of dollars. My concern with that by a certain date, my concern with that is if they don't pay that amount by that date.
Still a collections issue.
But it also, technically, it could expose them to contempt.
It may.
And they've already did a show cause back in the very beginning claiming that Karen was avoiding service. So we are concerned that they would in fact try to hold her in contempt.
All right.
I can't do that.
Your Honor, if I may.
You may.
Aside from this ongoing fiasco, which was all started by the defendant, she drafted the land contract, didn't pay, entered into a settlement agreement a year ago, approximately, didn't perform on it. She has no intention. Okay.
Right. I understand. I understand the nature of the arguments. All right. I understand the nature of the arguments on one and on the two previous that Ms. O'Brien has indicated. Any other arguments concerning a problem with the order?
And then, Your Honor, the court didn't order that they provide the driver's license, social security, employment information, but we agreed to do that. So I don't have an issue with that, but I just want to make that for the record, that is not a part of the court's order.
All right.
But we're willing to do that. Number 6, a hearing with respective counsel scheduled by this court regarding the matter of per diem. My recollection of when we were here a week ago was that you stated that the only thing that we were dealing with at this point in time is attorney fees because that was what was remanded by the circuit court. It's my understanding that Mr. Begg is relying upon something that you stated at the June 5th hearing. I did show up for court early today so that I could review the transcripts. However, I was advised by your staff that I was not able to review those transcripts since I didn't order a copy of them. So
right.
I don't know what you ordered.
Right.
I don't recall you were ordering per diem. However, Your Honor, for the sake of getting this over with, if there is a per diem charge, my client is just asking that she be given an offset for payments that she did in fact make during this time period.
You want to go over those payments? First off, Your Honor, I'm objecting to this.
Okay.
This is an unsigned accounting by somebody that's being now put on the record as proof.
He just asked for it. My client was on Zoom. I don't know where she went. She was in the ER all night with her husband. He's been in kidney failure for a week.
All right. So was a hearing with respect to counsel scheduled by the court regarding matter per diem, was that obviously wasn't a part of the original conditional dismissal, was it?
Again, Your Honor.
No, it was not.
But I don't have everything
Right.
memorized.
Yeah, if I remember correctly, and as I looked at the appeal on this matter, I just don't see that as a part of the conditional dismissal. So I'm going to strike part 6 of this, but I find parts 1 through 5 to be essentially what the court has ordered in regards to the reasonable fees, which were for the most part, and then the I agreed to itemized conditions that 3 and 4 don't seem to be a problem. 1, I find that language to be benign at the very least. So I just don't see, I see your point, Ms. O'Brien. I see how you're protecting your client, but I just don't see that language to be a mandate. It turns into a collections issue, which is part of the problem here. The court would sign an order and it'd be the date of the signature anyway. So we still have the collections issue. this only indicates that actually you get till August 31st and a place to send it, which seems to be directional more than mandated.
Well, can we add something in there, Your Honor, so that contempt proceedings cannot be brought?
No, I'm not going to add anything on there. You know, if they choose to, I think it's within their right. Okay, but on that level, that's something that would be coming, you know, come back to whatever court, maybe this court, to look at. I don't see that as a mandate in any way. All right. I understand you're trying to protect your client. It's more directional in nature. So with that understanding, I will sign 1, 2, 3, 4, 5. I'm going to strike 6 as I don't think it was part of the conditional dismissal to begin with. I don't see as scheduling a future hearing date as essential to what we're here today for. So I can strike 6, or you can resubmit an order without 6. It's up to you, Mr. Burch.
I strike it through.
All right. All right. So we'll strike 6. I find the order to be set now. So it's 1, 2, 3, 4, 5. I will sign the order to that effect. 6, 29, 20, 23. I will sign my name to it. It's not, it's prepared by yourself, Mr. Winters. Is that correct? You can say that for the record.
Yeah.
And Ms. O'Brien, you've had the opportunity to review it. Is that correct?
I have.
All right. With that understanding, you have your order now. Is possession still an issue here, or is that
Nope.
that ceased to be an issue?
Turned into a crap show.
Okay. All right. And that was as of June 24th. Is that correct? That's
It was
when
the 26th
the 26th.
at 4.
All right. All right.
Everybody was involved, sheriff.
Oh, all right. Well,
Yeah, well, Ms. Truskowski, as I stated, ended up in the emergency room, so
Right.
she was trying to get it cleaned out. She got her stuff out of there. She, I believe, was an hour late.
all right.
Mr. Birch showed up and the police had to be called.
All right. So in regards to this, I've signed the final order that was submitted today in regards to this. So that's,
Just so I'm clear, that's not the final order that closes.
yeah, that just closes the case. It's not the final order. That's true. I signed the order that was submitted today. That's actually, we got it today, but it was as of yesterday. And on this case, order submitted 6.
What do you mean it doesn't close?
And
We're not done yet.
And then I'll give it the file and the court. So the original will go in the file and you can get copies from my court officer. All right, sir?
Hold on. Point of clarification.
Yes,
Are we doing per diem issue today?
we are not doing it today. All right. I do not find it a part of the conditional dismissal.
So
And
we have to resue her?
well, you have to do something that was not in the conditional dismissal, because I don't believe it was ever in the conditional dismissal, anything about a per diem. There were conditions, and then the dismissal was based on that, and that's went to the Court of Appeals. It came back, and all we were looking at was reasonable fees and how to get them transferred. So that's my understanding of where we're at today.
But didn't you have something in a prior order where we're entitled to it per diem? We don't know what it is.
I don't remember anything in the appellate order to that effect. I'm willing to entertain a motion to that effect.
But the order didn't disturb your prior orders.
No, it's only the appellate order came back only as to reasonable fees. Everything else was affirmed.
Right.
So the conditional dismissal, if the per diem was not in the conditional dismissal, then I'm not familiar with what you signed, but if it was not in there, then I guess you could motion back up. Yes.
Okay.
All right.
All right, we will do that.
All right.
Now, we also have an issue of damages to the house, about $20,000 to $30,000.
That sounds like its own issue.
Okay.
Yeah, that sounds like its own civil issue here.
Okay, so we'll motion up per diem.
If you would like, and yeah,
She shouldn't be allowed to live there for free.
all right, and if it's in front of this court, it would be, I would consider that, and then any civil damages, but we're getting well over the 25,000 max. We're already over the 25,000 max for district court, so that might be better. filed in circuit court.
Yeah, but then we have to train somebody else.
But we're way over the, I mean, then we're up in the $45,000-$50,000 range.
It's only money.
Yeah, but we do have limitations. We have limitations.
I understand.
All right. Anything else for the file for today on 22-00875, Mr. Winter?
Nothing today, but again, reserving the discussion.
All right.
for the-
And thank you. Mr. Bryant?
Your Honor, I'm confused. The court has already ruled that they're not granting per diem, and he's continuing to say he's reserving the issue of per diem.
I
And
keep,
I'm confused.
well, Mr. Winter, of course, can file anything he chooses to file, and we'll go from there.
All right.
Okay?
Thank you, Your Honor.
All right, thank you. That's all for the
Thank you,
record in
Your Honor.
docket 22-00875.
Thank you, Your Honor.
We're gonna go to the copy of the,
What's that?
we're gonna go to
Right here, we'll give you,
complimentary
Mr.
copy.
Neff will give you a complimentary copy of both your orders, and the original will stay in the file.
Okay,
Thank you.
thank you very much.
Thank you, Your Honor.
Thank you. It's the first order, the one that I signed. I know there's a bunch.
Sorry, I
of
was
them.
late.
So, yeah, right here, these three. And I struck the last part.
Okay, thank you.
Mr. Abbott, how are you?
Well, sir, how are you?
Pretty good now that we're into the criminal docket, because that civil kind of gets me a little. $23,01795. That's people of the state of Michigan versus Damon Earl Kenny. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Damon Kenny. He's seated to my right.
Sir, you are Damon Earl Kenny? Okay. This is the time set for a preliminary examination. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, and after speaking with defense counsel, I believe that the parties have agreed to unconditionally waive their rights to hold a preliminary exam today. Consequently, I would move to bind over the case as charged in the complaint to circuit court. And just for the record, I would like to place, I believe I may have done the PCC, but I would like to place the offer that people have made on the record. And that would be for the defendant to plead to count 2, assault with a dangerous weapon, felonious assault, and count 3, controlled substance possession, cocaine, heroin, or another narcotic, 5 grams. And upon plea, count 1, the home invasion first degree would be dismissed. But obviously, after bind over negotiations, could continue up in circuit court.
All right. So the home invasion is dismissed upon successful plea. Negotiations to continue. And I want to make sure I've got these. So the possession is the count 3, right?
Yes.
It's not okay.
Yes, sir.
All right. And Mr. Abbott, I'll restate that offer for the record. So that's the current offer is a plea to count 2, it's the felonious assault 4-year, count 3, possession of cocaine, which is a 4-year, count 1 in circuit court upon successful completion of plea. The 20-year is dismissed and negotiations are to continue in circuit court. Is that your understanding, Mr. Abbott?
Yes, Your Honor.
All right. And does your client intend to waive his right to a preliminary examination today in district court?
Yes.
All right. So, Mr. Kenny, may I inquire your client of his advice of rights towards the preliminary examination? All right. So, Mr. Kenny, you understand you have a right to a preliminary examination within a certain amount of time here in district court?
Yes.
Okay. And a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed that crime. Do you understand that, sir? Right. You, of course, are represented by Attorney John Abbott from the Public Defender's Office, and he would be present to cross-examine any witnesses or contest any charges brought against you. Is that true? All right. It's my understanding you wish to waive your right to a preliminary examination in district court, have this case moved on to circuit court with the current offer that has been stated on the record and with negotiations to continue. Is that correct?
Yes.
Sure. Go ahead and ask him any questions you want. So we're on the record in docket 21-02458. That is the state of Michigan versus Ahmad Mohammed Mir. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
May it please the court, Deborah Martinez on behalf of the defendant, Ahmed Meyer, who is present via Zoom from the Ingham County Jail.
And sir, you are Ahmed Meyer?
Yes.
All right, thank you. You can hear me all right, Mr. Meyer?
Yep.
All right, this is the time set for preliminary examination. Actually, and this was a competency hearing for review, and we did receive a report on order of competency indicating the defendant is now competent to stand trial, which was the subject of conversation awaiting that competency report. And Mr. Brodowitz, you received that court? You received that report?
Yes, we did, Your Honor.
And Ms. Martinez, you received that report?
Yes, Your Honor, the court was kind enough to send it to us.
All right, and so any comment on the court signing the order or stip to the report and the court signing the order, Mr. Brodowitz?
No comment here. I would say, I guess I just believe that we are going to step and ask that from my conversation with the defense, there will be a stipulation and we'd ask the court to sign the order.
All right, is any comment, Ms. Martinez?
No, we agree that the order can be admitted into the record and that order of competency can be signed, so further proceedings can take place.
All right. Now, it's also so I've signed the order of competency and I'll provide a copy of both of that to both counsel. Based on that, we have a notice of intent to assert defense of insanity that was filed by Ms. Martinez, and a copy of that's been given to the prosecutor's office. And now, in order to evaluate for criminal responsibility, the order was given to date this morning, although we anticipated this. And Mr. Brodowitz, you have a copy of that order?
Yes, I do, Your Honor.
All right, Ms. Martinez, any comment on that?
Your Honor, only that under the statute, once the defense has filed the notice of intent, the court shall sign an order. So we would ask today that order signed to avoid any further delay with the Center for Forensic Psychiatry, as both parties in the court knows has an extreme backlog. So we'd like to do it sooner rather than later to get the process moving for Mr. Meyer, who's been incarcerated for some time.
Yeah, it's my understanding I've signed the order for criminal responsibility. It is signed, and the court will also provide a copy of that order to both counsel. And we've reset that, anticipating that it takes some time for the forensic the criminal responsibility report to get done and the evaluation to be done. And we've set this for September 8th at 8:30. And you have that date, Mr. Brodowitz?
September 8th at 8:30?
Yes. Ms. Martinez?
I have it, Your Honor.
All right.
That would just be a review date. Right?
So it's kind of a control date to make sure we have what is necessary to proceed. All right. Is that your understanding, Ms. Martinez?
Yes.
All right. So we'll provide copies of both the finding and order of competency and the order to both council. Anything else on the record in docket 21-02458, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Martinez?
No, thank you.
All right. And you'll explain all of this, but you haven't already, I know you've talked to your client,
Yes.
but you'll explain all this to Mr. Meir.
Yes.
All right.
Ahmed,
Miss- Go ahead.
Ahmed, I will come see you very soon, okay?
All right, thank you so much.
All right,
Okay,
thank
you're
you.
welcome.
You're all set, Mr. Meir, you're all set for this hearing today. Thank you, Mr. Brodowitz, and thank you, Ms. Martinez, for your
Thank you.
appearance.
So I'm free.
Right, so we're on the record in docket 170467. That's People of the State of Michigan versus Dominic Jackson. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Jackson.
And sir, you are Dominic Jackson?
Yes, sir.
All right, this is the time set for a probation violation hearing that we reset from 2 days ago. We had there were some I have technological issues, but I don't remember. Ms. Robinson, we'll defer to you at this stage. How are we proceeding today?
This will be a plea, Your Honor.
All right. Let me find the. So we're on the right. Is this for the March 5th, 218? Is that right? Or is that for the February 4th, 218? Trying to see if we have anything more recent.
If you tell me what the violation says, I might be able to answer better. Sorry,
Right.
Judge.
There was on the original form, there was an additional charge that was picked up on probation, and then a failed to correctly urine screen. And that was February 14th, 2018. Then there was a fail to appear for a probation violation arraignment that was issued by Judge Alderson.
I had the first one.
Okay, you have the first one?
Correct.
That seems like that's the original petition done by Heather DeHosky and signed by Judge Alderson. Is that the one we're talking about?
Yes.
Okay. So it is alleged that, so I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
It is alleged, signed by Judge Alderson on February 14, 2018. It was initially signed by probation officer Heather DeHosky on February 14, 2018. It is alleged you violated your probation in that you were charged with domestic violence with an incident date of December 17, 2017, while you were on probation, which is a violation of probation. How do you plead to that? Not guilty?
Well, he's asking you if you plead to not to like the actual charge itself,
Right.
but the probation violation of
Okay.
picking up a new
Right.
charge while on probation.
Did you pick up a new charge while on probation?
I believe so.
All right. And then there's also violation number 11, that you used a device to circumvent providing a urine screen at Adam on February 13, 2018. Do you plead guilty to that offense, sir? So that admission, okay. So that was a violation of probation. All right, I find that the admission to both violations to be voluntarily, accurately, and voluntarily made. So the admission to 2/14/2018. Violations. I find they're both technical violations. Admitted. Anything on the admission of the probation violations, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Robinson? Just on the admission of the probation violations.
No, Your Honor.
All right. And then we have a probation violation recommendation. Ms. Robinson, have you had the opportunity to see that?
I have.
All right. And you've gone over that with Mr. Jackson?
I have.
Okay. Allocution on that, and then I'll hear anything from the prosecutor's office.
Yes, Your Honor. We'd ask that you terminate Mr. Jackson from probation and sentence him to time served. Originally, this case was for marijuana possession back in 2017. Life got a little hectic for Mr. Jackson back then, and he's kind of just forgot about everything and all of that. He's been in for about 14 days now. And has really had time to sit and think and remember that he has these open cases and that he was on probation. He is doing great things. He's in the community. He's coaching a football team. He has a son that he takes care of, as well as he is working full time. So I don't think really keeping him in custody for too much longer based on the underlying charge of marijuana possession is really just in this case. And so we would be asking for termination of probation with time served.
All right, thank you. And it's my understanding that you pled guilty to the use of marijuana, which is the 90-day, correct?
I think so.
Yeah, I think he pled to the 90-day. All right, Mr. Brodowitz, anything concerning the probation violation sentencing on this matter?
The people would leave it to the court's discretion. Your
All
Honor.
right, this is an older case. It's a 2017 case. I think everything counsel's indicated is fair. You've got 14 days in on a 90-day, okay? I think that's more than compliance concerning this. And so it's just time to put this behind you correctly. So I'm gonna terminate probation. It'll be an unsuccessful probation. So I'll terminate probation unsuccessfully. Credit for time served. Which will be 14 days on the use. And I believe that's it. I give credit for time served on the use charge. Any fines and costs? All right, fines and costs will be administratively closed.
Thank you, Judge. And when it comes to his two other open cases, it appears that there is a remand for both of those. They are set for pretrial. As I stated earlier, he's been in custody for 14 days. These cases are older. They slipped his mind. I think he's well aware that he needs to come to court and will do so. So I would ask that those be converted to a personal recognizance bond.
What's the nature of those, the two pending? I just don't know what the nature of those. Okay, and how old are they?
2018.
All right. So, okay. Out of 2018. All right. I'll set, so you still have to address those. You still have to show up those, but you've got 14 days in. I'll PR bond those at $500.
Thank you, Judge.
All right. Yeah, well, we got to track those files down. When are they set for pretrial?
July
18th.
All right, July 18th. All right. So make sure you cover that so you can clean all this up. All right, sir? All right. Anything else for the record on docket 1704671, Mr. Brodowitz?
Nothing for the people.
Ms. Robinson?
No, Your Honor, thank you.
You're all set, Mr. Jackson. Thank you for your appearance.
Yeah, no problem.
So they get that stuff on.
The what? Your court date? Oh, yeah. It's through the computer and everything. They've got it already.
We just have to track down those files.
Yep. All right. See you guys later. Thank you.
All right. Thank you, Ms. Robinson. So Mr. Fife-Run Elamine, and then we have the credit acceptance for.
Before I screw this up, let me go find those two other files.
Yeah.
On the record. Won't be able to find that if anybody ever wants a record of it.
I can write in them.
I know, but there's nothing in the computer. Normally file the case to the record.
All right. Well, I can call them.
Easy morning. I like it.
What's that?
It's a quick and easy morning. I like it.
Thursdays. That was pretty quick for a Thursday.
Well, I think we might make up for it a little bit tomorrow.
Yeah. Tomorrow's we've got PCCs, some prelims, and I think we have Judge Buchanan's PCCs, right?
Yeah, we have. So. Then we also have that.
Those with them. So let's go and put those on the record. Well, these were PR bonded anyway.
Yeah, well, that's why I don't like to deal with the file,
Yeah,
because what she's
so-
telling me and what the computer says.
All right, so just to clear this up, we're on the record docket 1807469 and 1800712. That is people of the state of Michigan versus Dominic Jackson. And in regards to another file that we just terminated Mr. Jackson's probation on, we are going to, we've terminated, Mr. Jackson, on these is the last one was remand for pretrial. So I've set bond at reinstated bond on this case at PR $500 on both cases. Stated PR $500. So that's all for the record in docket 1807469 and 1800712. All right, Mr. Brodowitz, we'll see you tomorrow.
Yep, see you tomorrow.
All right.
Well, I may see you a little bit this afternoon.
Okay,
I may
that'll
tune in for Mr. Pfeiffer's.
show.
Yes,
All right.
Mr. Pfeiffer doing Pfeiffer things.
All right.
Thank you, Judge. That cleans that up.
Yeah,
I started to jump up to go get them, but you just started.
That's all right.
We
we can clean that up.
Yeah. Gino, somebody will ask.
Well, we don't want those files to be, we want something on the record and something in the files to indicate.
Yes.
2021, I'm assuming,